Research.
What's he doing?
Hello, the title of my paper is Reconciling the Use Commune with Common Law. F.W. Maitland, the prominent historian of English common law and co-author of the authoritative text, The History of English Law Before Edward I, stated in his inaugural lecture at the Art School at Cambridge, "History involves comparison, and the English lawyer who knew nothing and cared nothing for any system but his own hardly came of the idea of legal history." The task of my paper is to set out on an endeavor that has been traveled long before my time, however, with a new impetus due to our historical circumstances. It was clear that the old perennial debates concerning the historical relationship between the learned laws, commonly known as the jus commune, and the English common law has arisen once again. The question might arise, why rehash an academic debate that is yet to be resolved nor shows any prospect of reconciliation? This is a valid concern, yet it does not acknowledge the many advancements that legal historians have made in the last several decades, particularly in the study of the learned laws. This debate is also crucial in understanding, one, the relationship and indirect influence of the jus commune on the common law, which is the question of our research. Two, the relationship between the jus commune and the history of Anglo-American jurisprudence. Another question arises concerning legal chronology. At each stage of legal history, finding a chronological starting point is quite difficult. Hence, F.W. Maitland and Friedrich Pollock once famously said,
Sorry.
"You're good." Hence, F.W. Maitland and Friedrich Pollock once famously said, "Such is the unity of all history, that anyone who endeavors to tell a piece of it must feel that his first sentence tears a seamless web." No attempt will be made to trace the intellectual origins of the jus commune to its original sources. Neither is my claim that the English common law is merely an English iteration of the jus commune. Rather, the task of my research is to examine the influence of the jus commune on the development and growth of the common law and its institutions. There is a general consensus that the legal system was not received in the way that it was implemented into the legal fabric on the continent. However, it would be an abuse to say that there was no influence whatsoever. Edward D. Ray has succinctly delineated the different kinds of influence of the jus commune on the continent and on the British Isles. He says, whereas on the continent, the Roman law was utilized to meet the needs of changing social conditions, it is demonstrable that the English law borrowed foreign law to meet the increasing needs of a developing nation, great nation. There are tones of previous scholarship on the jus commune. This is simply an understatement. Second to constitutional and statutory interpretation, the relationship between Roman law, broadly understood, and the common law is a frequently discussed topic in law journals. The work of authors already mentioned, and some who are worthy of our recognition, such as R.H. Helmholtz and Charles Donahue Jr., have advanced and challenged a narrative that glooms over the research of the jus commune. There's a central theme that runs through the work of most English legal historians. This theme is a form of insular patriotism that drives a wedge between the popish canon law and the common law. A Spanish legal historian has noted that historians who are willing to acknowledge a greater level of influence of the jus commune on the common law are likely to be of continental or North American origin. The insularity is reasonable, likely stemming from religious prejudice that was animated from the Tudor to Stuart period. The hostility against the jus commune is particularly aimed toward the canon law, which was regarded as that ecclesiastical offshoot of Roman law, and the instruments to enslave English people to popes and emperors. William L. Burdick makes an accurate conclusion concerning this theme. This very term, Roman law, seemed to connect it with the Church of Rome, and probably many zealous adherents of the English church believed that they were prompting a righteous cause by discouraging the spread or even retention of civil law doctrines. It is best to be remembered that the original jurists who influenced the jus commune in Roman law were poor pagans who had no idea what a pope was. Another debate that I'd like to re-examine is this debate between F.W. Maitland and Bishop William Stubbs. Beautiful guys, as you can see. Another event that has shaped particularly 20th century scholarship on the youth community was the debate between Bishop William Stubbs and F.W. Maitland. Bishop Stubbs, whose dates are 1825 to 1901, was the Anglican Bishop of Oxford. Stubbs's Constitutional History of England was the standard work in the field of English constitutional history for a considerable amount of time. F.W. Maitland was an agnostic lawyer, Downing Professor of Laws of England at Cambridge, and whose scholarship was not as popular as Stubbs. However, the history of English law before Edward I remains the standard text for common law historians. The question of the debate was concerning the authority of papal law in the medieval Church of England. The position of Bishop Stubbs is best summarized in the report of the Ecclesiastical Court of Commissioners, which was published in 1883. The report states, "The canon law of Rome, though always regarded as a great authority in England, was not held to be binding on the courts. What is clear from the report is that the commissioners did not believe that papal law was binding either for secular courts or ecclesiastical." In response to Stubbs' position, Maitland responded with a series of articles, which was later published in book form as Roman Canon Law in the Church of England. Maitland's first three articles are nuanced and focus on different areas of Maitland's arguments. Maitland summarizes his position in the first article, in which he answers the commissioner's petition that the canon law of Rome was of great authority but not seen as binding. Maitland states, "In all probability, large portions, to say the least, of the canon law of Rome were regarded by the courts Christians in this country as absolutely binding statute law. Each of them, the Decretals, the Liber Sextus, and the Clementines, was a statute book deriving its force from the Pope, who published it, and who, being Pope, was competent to ordain binding statutes for the Catholic Church and every part thereof. At all events, within those spacious limits that were set even out to papal power by the Jus Divinum and Jus Naturale." It has been 124 years since the publication of Maitland's Roman Canon Law in the Church of England, and it is safe to say that his view is still generally held. Recent discoveries made by contemporary legal historians compels us to re-examine the Maitland versus Stubbs debate. Although Maitland's view has generally been accepted, it has been subject to revision and dispute. Charles Dungan states that Maitland was wrong to believe that the high percentage of decretals addressed to the Church of England and the decretals of Gregory IV was somehow an indication of the view of papal law in England. The high percentage of decretals to England had nothing to do with bringing England under the obedience of the papacy. Rather, the prominent English canonists made it a habit of collecting decretals. In the case of English legal historian J.W. Gray, the exception to Maitland's thesis is far more grave. Gray concludes that Maitland was correct with regards to legal theory. However, with regards to practice, the practice of papal law was wrong. Dean E.W. Kent's position is that Maitland's view of the decretals, the Liber Sextus, and the Clementines as absolutely binding law should be viewed as a specific set of cases for particular circumstances. What all three of these historians assert is that Maitland overstated his position, as the evidence will later display. Maitland's historical method has also come under scrutiny. Maitland does acknowledge in the beginning of Roman canon law in the Church of England that he merely dipped his toe into a vast collection of continental legal teaching. In the years since the Maitland versus Stubbs debate, a vast amount of records have been discovered that challenges Maitland's view of the character of English canonical litigation and the character of Roman law. A brief reconsideration of this debate, considering the evidence that has been made available, is worth our consideration. It would come to our surprise if we did not know more about the jus commune than Maitland did when he wrote in the 1890s. However, I would not like to begin with Maitland's inaccuracies, rather the particular instances where he was correct, and this will be brief. One instance is where Maitland proposed that Henry II's canonical conclusion was correct in dispute with Thomas Becket concerning the trial of Primus Clerks. We believed for a long time that Maitland's conclusions were incorrect. However, it would seem that Henry II gave a better canonical argument. Maitland knew of the existence of more ecclesiastical court records that were yet to be examined. Maitland, despite his lack of interest in the jus commune, encouraged that these records be explored. Maitland believed that his surmises concerning the jus commune would be proven wrong if explored. However, that has not been the case. Maitland was correct that uses were first enforced in ecclesiastical courts. Maitland was also correct to anticipate the church's attempt to provide guardianship to children. Despite Maitland's minimal factual errors on the nuances of the jus commune, his central thesis is the locus of scholarly dispute. Maitland's understanding of the papal decretals is ultimately misinformed. Papal law was not seen as binding by the popes that issued them and by the medieval canonists, and even less so in the litigation of ecclesiastical courts. As canon law historians have noted, the church courts possess broad jurisdiction over many matters. The 5 principal matters included marriage, probate, defamation, perjury, and tithes. What is important to acknowledge is the approach of medieval canonists to the papal decretals. The jus commune, in a sense, has always been skeptical of papal supremacy. Therefore, it was the practice of most medieval canonists to approach the decretals from a position of skepticism. Contrary to Maitland, the decretals were not seen as binding statute law. English litigation sometimes departed from the procedures of the papal decretals. The law of marriage and divorce, 2 of the church's 5 principal heads of jurisdiction, are in conformity with the papal decretals. However, in the area of defamation and the law of last wills, Maitland's theory falls apart. In these areas, the evidence indicates that the canonists departed from the decretals. Defamation in medieval practice meant the malicious imputation of a crime. English law, as declared by the provincial constitution enacted at Oxford in 1222, provided no remedy to injured parties. The decretals offered broad principles of relief. The case law found in the ecclesiastical records indicates that the canonists followed local English law rather than the guidelines of the decretals. Testamentary law also diverged from papal law in medieval England. There were also differences in jurisdictional patterns. Also, English law allowed probate of virtually any testament that could be satisfactorily proven. The necessity of 2 witnesses, as directed by the decretals, was not followed by the canonists. I do not intend to convey that the decretals played no role in how these cases were decided. What I do intend to convey is that the canonists did not view the papal decretals in the terms that Maitland uses. Having briefly sketched and hopefully clarified the Maitland versus Stubbs debate, let us now turn our attention to the Magna Carta. With that. There is no doubt in the minds of English-speaking people of the profound influence and contribution of the Magna Carta. Magna Carta has become a symbol for historical movements such as the American Revolution, women's suffrage, Indian independence, the creation of the EU. You can keep going on and on. The Magna Carta was a precursor to the English Bill of Rights and our American Bill of Rights. Concepts such as the due process of law owe its origins to the Magna Carta. Despite the Magna Carta's universal influence, the intellectual origins of the Magna Carta are often overlooked. Due to the constraint of time, I will not expound on the circumstances and context undergirding the Magna Carta. I trust that will already be assumed. However, I will compare some of the provisions from the Charter to what will be considered in 1215 contemporary canon law. Chapter 1 of the Magna Carta, so the right. Anyway, that side is in Latin, this side is English. I won't read the chapter, but you can kind of see it. The connection between the jus commune and the Magna Carta are obviously apparent in the first and last chapter of the Charter. Chapters 1 and 63 establish ecclesiastical independence. Amongst these freedoms, Chapter 1 strongly emphasizes the freedom of elections, which was, according to the Charter, the greatest necessity and importance of the English Church. The phrase "the English Church" and the appended guarantee of certain rights, although not frequently used, was not unknown to the canon law. A phrase like this was issued by letters from Innocent III. Although ecclesiastical independence was highly central to the first chapter of the Charter, there was a greater significance beyond that. The first chapter took its form from the Consentio Principis used in the Roman law. That is, these rights guarantees of the church were to remain perpetual and not solely limited to the lifetime of King John. Chapter 12 of Magna Carta. This chapter promises that King John would not levy any scutage or aid without common counsel. The aim of this chapter was to prevent arbitrary taxation by King John and all future kings. This chapter was read anachronistically to mean that parliamentary assent was required for the levying of any tax. However, its contextual meaning was referring to any process besides an institution. The Fourth Lateran Council sought to forbid the king from subjecting the church and clergy from tallages, taxes, and other exactions the same year the charter was signed. The principle that the king's power was not absolute but conditioned on the consent of the governed, especially the consent of the church and its clergy, was pervasive in contemporary canon law. Another chapter, just quickly, these chapters state a rule that would enjoy reception by the common law and common law jurists. That rule is amercement of both free men and villains by the king should be made only secundum modum delicti, that is, in accordance with the degree of the offense. Chapter 21 also invoked the same principle for earls and barons, adding that their amercements should be judged by their peers. The principle invoked is the principle of proportionality. Insofar as the records are concerned, this is the first appearance of this principle in the common law. The jus commune was absolutely identical with the charter in these chapters. Gratian's Decretum and the Glossa Ordinaria stated the same principle. Greater delicts were subject to, of course, greater penalties, and lesser delicts to lesser penalties. The assumption of the jus commune was a general principle adopted later by the common law, and even here in America. That is, punishment should correspond with the nature of the crime committed. Having compared the provisions of the charter to the jus commune, let us conclude our study by turning our attention to the Court of Chancery. This Court of Chancery, which has its decaying houses and blighted lands in every shire, which has its worn-out lunatic in every madhouse, and its dead in every churchyard. So remarked the 19th century novelist Charles Dickens in his novel Bleak House. I assure you that the Court of Chancery had a much more genteel origin than Dickens would have you believe. The Court of Chancery, known also as the Courts of Equity, began after the Norman Conquest in the ancient Curia Regis. The Curia is derived from the conception of the king as a feudal lord. One of the policies of the feudal system was that every vassal ought to render aid to his lord, either by his advice and counsel or by his sword in battle. Hence, after the Battle of Hastings, William I and his successors possessed earls and dukes beneath them as their vassals. Of the many officers that composed the council, this curia, the chancellor was the most important. The office of chancellor was made permanent under the reign of William II. The advent of the chancellor in the Court of Chancery displayed the maturity of the English legal system, and according to Maitland, saved the common law. As stated previously, the origins of the Court of Chancery were derived from the feudal system of the Norman kings. In the feudal system, the king was seen as the fountain of justice. The king obviously was not able to resolve all cases and disputes. Neither was the king able to offer relief to injured parties who believed no remedy existed at common law. The chancellor decided cases according to conscience and equity. Complaints were usually brought before the chancellor through bills or petitions, stating plainly that there were no remedy at common law. Petitions to the Court of Chancery differed formally from the common writ. First, the petitions to chancellors were originally written in French and English, not Latin, as was customary at the time. There was no crystallized format for petitions to chancery. Vocabulary could be amended and there was no fee. It was usually addressed to the chancellor in the form of a letter and was transcribed by a scribe in the king's court. The petitions usually contained three parts. One, petition to the chancellor. Two, the second part contained a statement of the petitioner's grievance. And three, lastly, the petition contained a prayer to God or an invocation of mercy. Up until the time of Sir Thomas More, the chancellors were ecclesiastics. This was done in part because of the belief that lawyers of the common law system would lack the courage to interfere with the rules of the common law. Chancery mixed justice with mercy, and its growth was an indicator of a significant development made in the common law. James I has a remarking statement that displays the influence of the jus gentium on the common law's equitable jurisdictions. He says, where the rigor of law in many cases will undo a subject, there the chancery tempers the law with equity, and so mixes mercy with justice. Christopher St. Germain, a barrister trained in the Inner Temple, confirms this understanding of equity. Germain was a erudite student of Roman canon law, and his book, Dialogues Between a Doctor of Divinity and a Student of the Common Law, he states the following: equity is the right wiseness that considereth all the particular circumstances of the deed, the which is also tempered with the sweetness of mercy, and such an equity must always be observed in every law of man, and every general rule thereof. And that knew he well that said that the laws covet to be ruled by equity. The Aristotelian understanding of epikeia was adopted not only by future students of divinity in the universities, but also by civilians in ecclesiastical courts. The court of chancery borrowed from the Roman conception of the praetor peregrinus, who rendered judgment not according to strict rules generally understood, rather according to the principles of the jus gentium, or equity. Primitive legal systems, such as the early Roman legal system, only offered pecuniary compensation. The notions of prevention and restriction are a later development. The chancellor, in tailoring specific remedies to injured parties, was a great contribution to the common law. The freedoms of the court of equity also allow the chancellors to draw from their ecclesiastical training. Viscount James Bryce, in his studies in history and jurisprudence, introduces the influence of the jus commune on the courts of equity. He says, our system of equity built up on the chancellors, the early among them ecclesiastics, takes not only its name, but its guiding and formative principles, and many of its positive rules from the Roman equitas, which was in substance identical with the law of nature and the jus gentium. Sir Henry Maine also observed, the jurisprudence of the Court of Chancery, which bears the name equity in England, derives its materials from several heterogeneous sources. The early ecclesiastical chancellors contributed to it from the canon law, many of the principles which lie deepest in the structure. The Roman law, more fertile than the canon law in rules applicable to secular disputes, was not seldom resorted to by a later generation of chancery judges, amid whose recorded dicta we often find entire texts in the Corpus Juris Civilis embedded with their terms unaltered, though their origin is never acknowledged. One thing that we have to notice is that chancery originally had no jurisdiction over testamentary matters. Therefore, chancellors felt bound to adopt the rules and procedures of the church courts. Oliver Wendell Holmes, although not a great Supreme Court justice or historian, was right to highlight that after the reign of Henry V, the Court of Chancery established a court that already borrowed the procedure of the canon law, which had been developed into a perfect system at the beginning of the 13th century. Even the great chair of the common law, shown here, William Blackstone, had to tame his bias against the popish ecclesiastics. Blackstone admitted that the proceedings of chancery are to this day in a force much conformed to the civil law. Although the intended audience of this paper are lawyers and legal historians, there are practical considerations that we can draw from this topic. One is the importance of historical honesty. Lawyers and legal historians all must concede some level of influence and departure from the jus commune. There is room for disagreement concerning the various levels of influence and departure. However, it is quite frankly a myth to say that one historical legal system does not influence the other. Two, this debate undergirds a lot of the debates of the influence of the Christian philosophical and theological tradition on the development of the common law and its institutions. And finally, it shapes our understanding of the development of Anglo-American jurisprudence and sheds light on various constitutional debates in the United States. Constitutional debates concerning Article 3 courts and the equity powers of injunctions, specific performance, and declaratory judgments can be read in a new light when the intellectual origins of the federal court's equity powers are properly understood. The common law heritage is the treasure that our founders inherited. Our common law heritage must be properly understood, contextualized, and defended against its enemies today. Understanding the common law's relationship to the jus commune and reconciling the two like friend adoring friend can equip us today in conserving the great treasures that undergird our constitutional order.